Hi, my name is Corey Biazzo, and I'm a practicing American civil litigation attorney. In today's episode, we're going to discuss some of the legal issues surrounding the Kilmar Armando Garcia deportation case. To sum up the factual account of the case based on court pleadings and the current ongoing litigation of this matter, Mr. Garcia is an individual from El Salvador who entered the U.S. unlawfully that was living in Maryland with his U.S. citizen wife and children. Law enforcement officials and politicians, including President Trump, have made allegations that Mr. Garcia was a member of the infamous MS-13 gang and that he has a history of domestic violence, among other allegations. However, in 2019, a U.S. immigration court in Maryland entered an order forbidding the U.S. government from removing Mr. Garcia based on an application for asylum that Mr. Garcia submitted. The application refuted the allegations that Mr. Garcia was affiliated with any gangs or criminal activity and stated that Mr. Garcia fled to the U.S. from gang violence directed at a food business that his family owned in El Salvador. Mr. Garcia was apprehended by immigration enforcement officers in Maryland on March 12, 2025, and without any type of legal process, notice, hearing, etc., was deported to El Salvador on March 15, 2025, and detained in El Salvador's infamous CSOT prison that is facing allegations of human rights abuses. Since this occurred, the federal court for the District of Maryland has ordered that the deportation was in violation of Section 8, United States Code, Section 1231, and more importantly, of the Fifth Amendment of the U.S. Constitution. The court ordered that the Trump administration facilitate Mr. Garcia's return to the U.S. to restore Mr. Garcia's status before he was unlawfully deported, so he could be afforded due process in accordance with the U.S. Constitution and governing U.S. immigration laws. The Trump administration appealed the order up to the U.S. Supreme Court, who upheld the trial court's order in a brief 9-0 opinion issued on April 10, 2025. However, the administration has, as of the time of this video, May 8, 2025, failed to facilitate Mr. Garcia's return to the U.S. This case is back at the trial court for further proceedings. The court seems poised to address the administration's possible contempt of court for the administration's failure to facilitate Mr. Garcia's return in accordance with the trial court order that was upheld by the U.S. Supreme Court. Today we will address the Fifth Amendment and the U.S. Constitution. The Fifth Amendment states in part that no person shall be deprived of life, liberty, or property without due process of law. The clause requires that any individual be provided with appropriate prior notice and an opportunity to be heard prior to when the federal government may take life, liberty, or property from an individual. In fact, the late Justice Antonin Scalia, in writing the majority opinion for the court in a case called Reno versus Flores in 1993, stated, "It is well established that the Fifth Amendment entitles aliens to due process of law. While the President has the power to enforce federal law pursuant to Article 2 of the U.S. Constitution, the President and the administration do not have the authority to violate federal statutes and the U.S. Constitution." Here, the executive branch violated Mr. Garcia's Fifth Amendment due process rights by failing to provide him with sufficient advance legal notice and an opportunity to be heard on the merits of the executive branch's intent to deport Mr. Garcia by a judge prior to his deportation. If the government has a strong case against Mr. Garcia and sufficient evidence against Mr. Garcia, the government should give Mr. Garcia his day in court after they abide by the 9-0 Supreme Court affirmed order to facilitate Mr. Garcia's return to the United States from El Salvador so he can be afforded his day in court before a final decision on whether the 2019 order preventing his deportation can be lifted to facilitate a valid and lawful deportation of Mr. Garcia. Keep an eye on whether the administration voluntarily comes into compliance with the order or whether the judiciary's broad statutorily affirmed contempt authority is utilized to corral the administration's compliance with the order. Briefly, contempt authority includes the authority for a court to issue monetary fines and incarcerate individuals until they purge their contempt of court. As of the time of this episode, discovery is being conducted for the plaintiffs to learn which officials in the Trump administration are directing actions and inactions to violate the order for almost a month. It appears a new dispute came to light yesterday, with the administration attempting to invoke an executive state secrets doctrine to avoid responding to discovery. Stay posted and follow the executive coup for more updates on this matter and others related to the apparent coup attempt coming from the executive branch of the United States federal government. Thank you.